Unions may strike to put pressure on employers in labor disputes, but they're not allowed to use strikes to try to force an employer to stop doing business with some other entity. These so-called secondary boycotts were the topic of National Labor Relations Board versus Denver Building and Construction Trades Council. Contractor Doose and Lintner was constructing a building in Denver. Most of the employees on the job were members of craft unions affiliated with the Denver Building and Construction Trades Council. However, Doose had subcontracted with Gould and Preisner for some electrical work and supplies. Gould's employees were non-union. Gould had a long-standing practice of hiring non-union workers, which was a point of contention between Gould and the council. When a union representative complained that union men couldn't work with non-union men, Gould replied that its workers would stay and finish the electrical work unless bodily removed. The union representative replied that the situation would get very difficult for both Gould and Doose. The council told its members that it was unfair for them to work with non-union members and organized a strike. Union members picketed the job and stopped working for 2 weeks. They carried signs that read, quote, "This job unfair to Denver Building and Construction Trades Council," unquote. Doose fired Gould. The unions came back to work and finished the job. Gould filed a complaint with the National Labor Relations Board. It argued that the council had engaged in an unfair labor practice by engaging in a strike to force Doose to stop doing business with a non-union subcontractor. The board found that the council had engaged in an unfair labor practice and issued a cease and desist order. The District of Columbia Circuit reversed, finding that the strike was a primary boycott. The board appealed to the United States Supreme Court.